Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Koehler, and I invite you to my next FCPA Institute in Nashville on May 4th through the 5th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Koehler, and in this episode I'm pleased to be joined by Judy Krieg. Ms. Krieg is a U.S. educated lawyer and currently a partner in the United Kingdom offices of Shepherd and Wedderburn. Previously, Ms. Krieg served as a financial regulator at the UK Financial Services Authority and as a chief compliance officer and in-house counsel with various companies. She has experience in both the UK Bribery Act and the U.S. Foreign Corrupt Practices Act. Thanks for joining us today, Judy.
Thank you, Mike.
Today's topic is all about deferred prosecution agreements. And you recently wrote a piece that caught my eye titled UK Deferred Prosecution Agreements. Have we really built a better mousetrap? And just for listeners' benefits, the UK adopted DPAs in 2014 as an option to resolve various economic crimes, including Bribery Act offenses. However, the UK DPA regime is much different than the US DPA regime. Can you please start by providing for listeners a short primer on UK DPAs and how they are different from US deferred prosecution agreements?
Well, I wouldn't say that the UK DPAs are very different than the way that the US does them, and in fact, there's no question that when the UK looked to put a DPA regime in place, they looked to the US model. And a lot of what we do here in the UK is in fact taken, if not primarily, then wholesale out of the US model. But when the UK decided that they wanted their own DPA mechanism, there were some concerns that they had about the way that DPAs were operating in the U.S., and they were very clear about the fact that they wanted to improve on the U.S. process in some very tangible ways. And specifically, what the UK wanted to do with its own process was to build in more transparency and greater judicial involvement. And this is all quite clear from the consultation process that was used in the UK as the DPA process was formulated. The Brits wanted the public to have confidence that when DPAs were entered into, they weren't a cozy deal, and that was the words that were used, and that it wasn't a rubber stamp exercise. So what they designed was a slightly different process that ensured that the public cannot only see the deferred prosecution agreement itself, which of course is a feature of the U.S. system, but also the public could see the reasons why the DPA was entered into, and that a judge wasn't just rubber stamping what the parties had agreed, but rather that the judges had more involvement and had to make specific findings, and findings that were documented and also made public. So I'll focus on two ways in which the UK process is different from the U.S. process and the way that that's playing out in practice. The first way that the process of DPAs is very different in the UK is the level of judicial involvement and the way that the judges are involved. So there's two hearings, can be more, but ideally two hearings in front of a judge in order to determine if DPA is, the judge has to make several findings. First of all, the judge has to find that the deferred prosecution agreement is in the interests of justice, and that's a common term in the UK, and it's in a lot of the rules and regulations that govern how these things work. So the judge has to find that the DPA is in the interest of justice and that the terms are fair, reasonable, and proportionate. In order for the parties, the prosecutor and the corporate, to be able to discuss this with the judge, there's two hearings that are held. The first hearing is a preliminary hearing in private, where the parties present to the judge the proposed deferred prosecution agreement, and they discuss it with the judge. And the reason that that's done in private is because the parties want to be able to have that discussion with the judge and have a candid discussion with the judge, but they also wanted to maintain confidentiality in the event that the judge decides not to approve the deferred prosecution agreement. So the first hearing is a preliminary hearing, and it's confidential. It's held in private. If the judge, at that point, the judge can either decide that he's not going to approve the DPA, he cannot make the required findings, namely that it's in the interest of justice and the terms are fair, reasonable, and proportionate, or the judge may find that it is. If the judge finds that it's not, he can't make the findings, then the prosecutor and the parties can go back and try again. That's not just a one-shot deal. But if the judge does find that the proposed DPA meets the standard, then there's a second hearing, and that hearing is typically public. It doesn't have to be public, but it is typically public. And at that point, if the judge approves the DPA, as well as the reasons for the judge's findings that it is in the interest of justice and the terms are fair, reasonable, proportionate, are all made public. So what you end up with when you do get through the UK process is not just the DPA itself, which has the same general sections as in the U.S. DPA, but you also have public the judge's findings and the reasons for the judge making those findings. So the idea is that between that process, what would end up at the end of the day is a DPA that is more transparent and more public in terms of how we got there. That's the theory behind it. And so the key difference that I would say between the way it's done in the UK and in the US is that two-stage judicial process and the specific findings that the judge has to make. I think there's also an important stylistic difference that is proven to have some effect on the UK DPAs. And that comes into play in the way that the statement of facts is written. If you take a look, for example, at the Royce DPAs, there's one in the U.S. and there's one in the U.K. And if you just take a glance through the statement of facts in each, they're written in very different styles. And the U.K. statement of facts is, first of all, much longer. It goes into much more detail. And even does things like quote emails and quote documents. And it will name, in some instances, it will name customers. It won't name third-party intermediaries, but it does name competitors that may have been disadvantaged by the situation. But so the UK has a process where it's much more voluminous in the facts that are made public that underpin the DPA and also underpin the indictment. The U.S. style is much leaner. It is just not as specific, and of course, as we all know from trying to read these things, you use things like intermediary number 3 or a senior executive or executive number 7. The Americans do that as well, and it makes it very difficult to follow, but at the end of the day, the American statement of facts is just much more concise and not as detailed. And I think that when you look at the difference between the two, it's quite clear, and I think it's gotten the UK SFO in a bit of, not trouble, but a bit of difficulties as a result.
Yeah, thanks for providing that overview, and I guess some other differences would be the United States also has non-prosecution agreements, whereas the UK very early in this process rejected non-prosecution agreements as being inconsistent with its constitutional principles. I guess another difference perhaps would be that DPAs emerged in the UK as a result of a deliberative legislative process rather than the SFO just on its own initiative and exercising its own discretion started using them, which is sort of what happened in the United States in the FCPA context in 2004. So if a country is to have deferred prosecution agreements, I think for the reasons you mentioned, transparency, more active and early judicial involvement, I think the UK DPA model is preferable, but I guess that just begs the overall question of whether DPAs of any form are in the public interest.
I agree with that, Mike, and I think that's, if you look at the theory behind the differences in the UK system, the transparency and more public awareness or information about not just the agreement but why it was entered into, the theory is good. But if you look at what's happened in practice, and I think it's a function of just what's happens when you're trying to enter into a DPA. Realistically, you have a prosecutor who has an incentive, whatever that may be, to enter into an agreement, and you have a corporate who certainly has an incentive to enter into an agreement. And when you do have two parties that are willing to enter into an agreement, present what they choose to present to a judge for approval, are you ever going to get something that is fully transparent?
Yeah, and you mentioned in your piece, or you posed the question in your piece, quote, has the UK really built a better DPA mechanism? And you answered that question, not yet. Now, granted, the UK DPA regime is still very much in its infancy. There's been, approximately 5 DPAs entered into, including a couple in the Bribery Act context, But can you explain what you meant by the UK has really not yet built a better DPA mechanism?
Well, if you come back to the whole purpose of the UK making these changes, is that there's a public confidence that this is not a rubber stamp exercise, we're not there yet. If you look at the DPAs that have been entered into, the first one here was the standard Bank DPA, and as we can discuss, that's come under some criticism, and I think that there is at least a fair interpretation that leaves open to questioning whether or not that was a rubber stamp exercise or not. The second DPA that was entered into is a XYZ, which is a name of a company that hasn't been disclosed because criminal proceedings are underway. And so we haven't seen the factual statement in that case. So obviously that wasn't quite as transparent as we would hope. And then the third one in the bribery context is Rolls-Royce, and which is also part of that has come into question as a result of what's been filed. There is a fourth DPA that is in the process. It's about to come up to its final hearing, and that's Tesco. And of course, we don't really know what that looks like yet because none of those papers have been made public. But if the idea behind these enhancements, if you will, to the way that the U.S. does it is to make it look like there's less, I don't want to say collusion, but less of a foregone conclusion presented to a judge, we haven't yet seen a situation where a DPA has been rejected by a judge. We haven't seen a situation where the judge has changed the terms of DPA, and you can read what Judge Levison has said about the DPAs that have been approved so far. They've all been approved by the same judge. And what it has done, because the process that is in place here doesn't really allow for any input by anyone other than the prosecutor and the defendant company, there is questions that are being raised about these DPAs, but they're being raised after the fact, and they're being raised in the media and elsewhere because there is no mechanism for anybody else who's affected by the DPA or wants to raise questions about the DPA to actually raise those questions. So if the idea, again, is to try to create a transparent public process that avoids the perception of a rubber stamp by the judge, we're not quite there yet in the UK.
Yeah, and you mentioned judicial scrutiny, but at present we have judicial scrutiny by one person, the same judge. Is there perhaps a practical reason or other reason why all these DPAs have been assigned to the exact same judge?
I can't answer that because I don't know, but there are people that are raising questions about whether Judge Leveson is really best placed to deal with the Tesco DPA, and he is the one who's scheduled to deal with it.
Yeah, I mean, just from my perspective, when this started, you're like, oh, great, judicial scrutiny, but judicial scrutiny by a judge is, of course, important, but is judicial scrutiny time and time again by the same exact judge? That's kind of odd. I know there's some probably efficiencies in having the same judge do this because it's a new process, but time will tell whether there will be additional judges in the UK, hopefully, that will opine and contribute to this process as well.
I agree.
Now, you mentioned the Standard Bank and Rolls-Royce DPA, and you say in the piece you wrote that these DPAs have had their accuracy and financial underpinnings questioned. Can you explain that in a bit more detail?
Yeah, I think Standard Bank was a pretty remarkable DPA, and particularly for the first one out. So what happened in Standard Bank is that the UK Standard Bank was the entity that entered into the DPA with the Serious Fraud Office, but the bribery that had happened occurred in a subsidiary, a sister company, Stanbic, in Tanzania, and the bribery happened by Stanbic employees, and they bribed Tanzanian government officials to get a mandate to help the Tanzanian government raise some funds. Now, what happened in the Standard Bank DPA, and again, this was the first one out of the gates here in the UK, is that the factual statement of the DPA actually named names of the bank employees who allegedly paid the bribes. And Judge Leveson made a specific finding that was appropriate to do. It was not without controversy here in the UK, again, after the fact, because the process doesn't really allow for anyone to input into this other than the SFO and the culprit and the judge. But after this became public and the names of these three employees became public, it was a bit surprising, particularly for a country that does tend to value privacy of third parties to these sorts of proceedings. One of the individuals was a woman named Soche Senare, and I'm sure I'm mispronouncing her name, but in any event, because she'd been named in a public document in the UK as having paid a bribe on behalf of her employer, she actually took a bit of exception to it. Now, what she says, and she's now said publicly, because she's suing Standard Bank for defamation over this, what she says is that she was never properly interviewed. No one actually asked her the full extent of what had happened. And a key finding by Judge Leveson in order to enter the DPA against UK Standard Bank was that the bribery that had happened was known in Tanzania, but that the UK branch of Standard Bank didn't know about it. Well, Soche Senare says that's not the case. And if anyone had asked her, she says, information that she can prove that the UK part of Standard Bank knew what was going on. Now, there was a petition that was I haven't seen it, but there was a petition, according to internet reports, to reopen the Standard Bank case, and the SFO responded, and the SFO's response was, no, we're not going to do that. We're done with this. Now, I found that personally a bit surprising, because you would imagine that if somebody said to the U.S. Department of Justice, hey, guess what? We think that you may not have known all the facts when you agreed this deferred prosecution agreement, the DOJ isn't going to take particularly kindly to the notion that they haven't been presented with all the facts. And one common feature of both U.S. and UK DPAs is that the company that enters into it does have to give some sort of assurances that they have given a full and frank disclosure. And one of the basis for reopening a DPA in the UK is if that hasn't happened. Well, the SFO said, no, we're not going to proceed with this any further, and so now we've got a public we've got DPAs made public, and we've got a woman in Tanzania saying that I think a foundational premise of that DPA is being called into question. Namely, should the UK bank been looked at with a bit more scrutiny in terms of what they knew and when they knew it? You would imagine also that this is something that I hope Judge Leveson took on board, because he was presented with a statement of facts from the SFO and agreed by Standard Bank, and now there's a third party saying that's not really quite all the facts, and nevertheless the DPA stands.
Yeah, I mean, it's an interesting question, and, I and others can ask this question a lot of times in connection with U.S. DPAs and MPAs. Are these just a vehicle to make the DOJ and or SEC go away? Are they necessarily a search for the truth, or are they just a game of risk aversion? And, perhaps not perfect parallels to the situation you described, but, there definitely is an open question there as to the underlying factual support for certain aspects of that Standard Bank agreement. What about the Rolls-Royce agreement? You also mentioned there that some of the accuracy or financial underpinnings there have also been questioned.
Well, can I come back to Standard Bank for a minute? Because she's not just raising these claims in a vacuum. What she also says is that she was told that she shouldn't point the finger at the UK because the UK branch of Standard Bank could lose its banking license, and since Standard Bank was trying to sell majority interest in the bank to a third party, a Chinese third party, that could cause problems for that transaction. That actually was going on. So what Jose Sonari is claiming, and again, this is what she's claiming, and I'm not saying that it's true. What she's claiming is not just that she was told don't point the finger at the UK, but she was given a pretty specific commercial reason why doing that would not have been in Standard Bank's interests. And what she's saying shows why it would have absolutely been in Standard Bank's interest to get a DPA done and dusted. I think that there's more to it than just that you didn't quite get your facts straight. And you would think that in a process that, again, is trying to be transparent and public and try to show that it's not a rubber stamp, that would cause some people to pause for thought. But so the Rolls-Royce DPA, obviously there were some lessons learned from Standard Bank in that there were no individuals named in the Rolls-Royce statement of facts. So I think that probably became clear that wasn't a great idea. But what happened with the Rolls-Royce DPA, and I'll talk on the UK side of the fence, there's one particular part of it. It's the last count in the UK DPA, and it has to do with a bribe paid to Air Asia, which is a commercial airline in, I think it's Indonesia. And the DPA, the count in the DPA is that Rolls-Royce paid a bribe or gave a bribe to a senior executive at Air Asia who had his own private aircraft. And so what Rolls-Royce said to this executive, or rather the executive said to Rolls-Royce, is, I want you to put into this deal with Air Asia $3 million worth of servicing on my private aircraft, but I want you to word this in a very vague way so that Air Asia doesn't really know what's going on in the deal. And what the DPA statement of facts says is this was the inducement for this senior executive at Air Asia to make sure that Rolls-Royce got the deal, and it did include $3 million worth of servicing to his private aircraft, but Air Asia wasn't really fully aware of that. That's what's in the DPA. And again, it's quite detailed. It talks about conversations and discussions between employees at Rolls-Royce, and documents are quoted. That's the count in the DPA. Well, after the Rolls-Royce DPA was made public, Air Asia came out and begged to differ. Air Asia says that not only did they know about that arrangement all along, but they actually disclosed that arrangement in the IPO filing for Air Asia when it went public. So you've got a count of a DPA that is based on a secret benefit, allegedly an undisclosed benefit to an individual, and then as soon as the DPA comes out, you've got the company who allegedly was duped by all this saying, no, actually we knew about it all along. I think that questions not just the facts, but the legal basis for that particular count of the DPA, and again shows how the UK style of a statement of facts, a very detailed statement of facts, can come back to raise more questions than I think it answers. And again, in the quest of a UK process that is more transparent and public than in the US.
I mean, of course, in the United States, because names aren't named and companies generally aren't named, both of these examples probably would never have been talked about in the public domain because they're simply not names. So that's an interesting comparison and further to why transparency, which the DOJ and SEC always preach in terms of their FCPA enforcement program, I think is important for some of these after the fact reasons you're mentioning. The final question I have sort of asks you to predict the future, I guess, and let me just start by a comparative point. When NPAs and DPAs were first introduced to the FCPA context and put in the U.S. Attorney's Manual, they were only to be used, quote, under appropriate circumstances. However, time has indicated that appropriate circumstances appear to be nearly all circumstances because the vast majority of corporate FCPA enforcement actions, with a few exceptions, do involve either an MPA or a DPA. So what do you think is going to happen in the UK? I know that these resolution vehicles were never intended to be the quote-unquote normal way of resolving things, but do you think that DPAs will become the norm rather than the exception?
Well, what I'll say is that the Rolls-Royce DPA has not been without controversy over here, in that the Serious Fraud Office was very clear that you had to self-report in order to really be eligible for a deferred prosecution agreement. And Rolls-Royce has really questioned that because the DPA itself says that Rolls-Royce is not considered to have self-reported. And nevertheless, they got a DPA, and they got a DPA with a very significant discount off of what could have been the fine. Now, if you compare that with an example here in the UK, the Sweet Group, where the company was not given the opportunity of a DPA, and instead the company ended up pleaded guilty. So you're right, there's no NPA, there's no middle ground here. But if you think about DPAs as trying to induce companies to self-report, I think that Rolls-Royce has shown that that's not always the case. But what that also shows is that whatever you think are the baseline requirements to be eligible for a DPA, you may or may not be right of what they look like at the end of the day. I mean, what we're seeing in the UK is that, Rolls-Royce took several years to come to fruition. It is the first, I would say, significant deferred prosecution agreement that's come out of the UK process. There are several others that just appeared to be stuck in the mud. Very, very high-profile names like GlaxoSmithKline, Barclays. Now, obviously, Tesco's has finally gotten out of the gates, and we're halfway through in terms of where we are. But what's happening here in the UK is significant matters. Significant corporates and big issues are getting bogged down in the DPA process, but I do think ultimately you're looking at a deferred prosecution agreement. The DPAs in the UK have also come under criticism because if you do look at, for example, the Sweet Group, which it wasn't a DPA, it was a guilty plea, but Standard Bank, it's self-reporting. And, they're not necessarily significant companies or significant matters, but, this is what you get for coming forward and self-reporting. You're going to, if you're lucky, get a DPA if the evidence is there. So I think we're seeing is almost a dichotomy. You're seeing the little fish that self-report getting a DPA, and whether or not that's going to encourage companies to self-report, we'll see. And whether or not that causes DPAs to dry up because companies don't self-report, we'll see. But we are seeing the DPAs slowly working their way through the system in the major corporates. I do think you're going to see some additional DPAs coming forward in the next few months, but it could be longer than that. Things here always seem to take longer than you think. But there's no question that, that whole calculus of do you self-report, and of course we haven't talked about it, but the other big question of do you waive privilege over your witness interviews, all of this is still just finding its way through the system. And if the answer is that there's a bit more fluidity about the circumstances under which a company can get a DPA, I don't think there's ever going to be a shortage of companies that find themselves on the wrong end of a factual scenario where wrongdoing is done. And when you get there, those companies are going to have every incentive to make sure that it gets resolved through a DPA mechanism. And I don't think you're going to see this go away anytime soon.
Well, anytime a law enforcement agency deviates from traditional law enforcement principles and creates and invents new ways of resolving cases, you are going to see some of these issues pop up and play themselves out. And I thank you for taking listeners of the podcast through an overview of the UK DPA regime, some of the recent DPAs used to resolve Bribery Act offenses, and some of the controversies and policy concerns regarding the current DPA regime. So today's guest has been Judy Krieg. Again, Judy is a U.S. Lawyer in the UK offices of Shepherd and Wedderburn, and has experiences with both the Bribery Act and Foreign Corrupt Practices Act. And thank you for educating FCPA Flash listeners today on these topics.
Thank you.